In the past couple of years, the Department of Homeland Security has stepped up its efforts to enforce the laws regarding the hiring of illegal immigrants. This short video goes over the fundamentals of what builders need to know to protect themselves from this heightened enforcement. The Immigration Reform and Control Act of 1986 is the current law of the land. It made hiring illegal aliens unlawful while placing the burden of verification on the employers. This is done through the I-9 form. Employees must be careful not to determine hiring based on foreign appearance, or they could face discrimination lawsuits and penalties. Let's take a look at the I-9 process. An employer must have one I-9 form for each employee hired. Employment eligibility can only be verified after the worker has been hired. It is legal for employers to pre-screen prospective hires. Fill out the I-9 form only after the candidate has been hired. Section 1 of the I-9 form asking for common information should be filled out the day of the hire. You then have up to 3 days to complete Section 2 of the form that shows you have collected and documented the eligible documents for verification. Keep in mind that only original documents can be used for verification, and that all documents must be returned to the employee after the information has been recorded. You need to keep I-9s for 3 years after hire or 1 year after separation, whichever is longer. You may now keep these records electronically, but it's your responsibility to have these records in a secure area that can be accessed if requested. Note that photocopying documents, while allowed, is in no way required. Many people photocopy documents, not realizing that they become part of the official I-9 records. It is also a good idea to regularly perform self-audits to make sure you are in compliance. If you find any errors, document the correction. Don't backdate any documents. Simply have the employee sign off on any corrections. There are basically 2 ways the Immigration and Customs Enforcement Agency, or ICE, enforces the law. The first method is through an audit. ICE officials need to give you 3 days written notice prior to your audit meeting. A subpoena is neither issued nor needed. You simply need to produce the required I-9 documents as required by law. If you get an audit notice, called a Notice of Inspection, be sure to read it carefully. It will contain specific instructions for you to follow. In some cases, ICE has been known to ask for more information than is legally required. That is why it's important to contact your attorney as soon as possible. Have them work with ICE directly and make sure that they are present while the audit is being conducted. If ICE finds any errors or discrepancies, they may issue you a Notice of Intent to Fine. Expect penalties to range from $100 to $1,100 per infraction. Once issued a Notice of Intent to File, you have 30 days to contest the penalties with an administrative law judge. It is in front of them that you would present any mitigating factors that you and your attorney feel could help your case. The other form of enforcement by ICE involves raids. Unfortunately, raids can be very traumatic and can happen without warning. It is important that you not hinder the investigation in any way. Call your attorney immediately and follow their instructions. Above all, do not volunteer any information without approval from your attorney. To get more information on this issue, including the latest news, developments, and resources, log on to nehb.org/immigration. And remember, NEHB is working for you.